All right, good afternoon, everybody. My name is Christy Hopper. I'm the marketing manager here at Valiant, and I will be your moderator. We're so pleased you guys could join us today for this important update to the restaurant compliance landscape. So we're super excited to have employment law expert Amanda Fugazy on hand, as well as Valiant's CEO Jeff Weinstein, to walk you through the most recent changes and share the best practices in the space. But before we begin, I just wanted to review the format really quick. You guys have a grab tab to the right of your screen where you can minimize the window so it's out of the way. But you can also use the tab to post questions where it says questions box. We're going to fit in a few of your questions towards the close of the webinar for Amanda and Jeff to answer. So with that, I'd like to open the floor to Valiant CEO Jeff Weinstein to start us off. Hi, Jeff.
Hi, Christy, and thanks everybody for being on the call today and taking time out of your day to listen to this. And Christy and to the team, thanks for arranging everything. And Amanda, great to be doing this with you. I think just generally, I think the thing that's kind of going on in the restaurant space that we want to talk about today is a lot of things that are around compliance issues, around tip credits, federal taxes, new rules of reporting, different ways to interact with your employees and those kind of things. So we wanted to talk about, those things and give you, an update, at least from our perspective and Amanda's perspective, on some of the things that are going on in the space that I think as owners, operators, you want to be thinking about, and some things we want to kind of bring to light. Next slide. So just a little bit about us, if you're not familiar with us. We're an organization that's been in this business for about 25 years, and really we're a specialist in the whole space of hourly workforce, human capital management, and so being in that space about hourly employees and organizations that are hourly employees. It's no coincidence that we find ourselves that we do a lot in the restaurant space, and also we do a lot in the security space. So for us, we're really a software firm and a services firm that focuses on payroll scheduling and human resources. And today we have roughly about 1,500 clients across 33 states, including Canada and Puerto Rico. So we have a good expertise in this, and we've been doing this for a long time. So we have some good visibility into, from our clients and from just being in the space and really trying to be both an innovator and somebody very pragmatic on how we help customers solve this. I think we have a good perspective on this that we kind of wanted to always be kind of sharing with you. Next slide. So look, there's a lot going on here. Some things around the things that you as owners and employee and management are thinking about. There's some confusion and some more specific insight that's needed around things around wages and benefits and pay stub legibility requirements and how that relates to state and federal guidelines. So that's some of the things that we want to talk about. We like to see ourselves, as both not only a solution but also an advocate for our customers on how they're able to deal with these changes that are happening and how we're going about that. In part of that, these changes that are happening in this market that are basically from the government and state agencies and those kind of things. We like to also see ourselves as an enabler. So when the new federal tax guidelines came in place, we have somewhere like 5,000 tax tables across all the states that we're managing to be able to figure out how to address that easily, so it's something that you don't have to kind of deal with on your own. And with our payroll engine, we feel like it has that flexibility to be able, whatever that calculation is around how tip credits go and how direct or indirect tip credit reporting is done, and also how we're making payroll stubs more legible for everybody to understand. So we're feeling like we want to be an enabler to that, not only be an advocate for how you're thinking about things, but how to be an enabler in that area. Next slide. So kind of going down that path, when we're thinking about ourselves in that area and being an advocate, we do spend a lot of time thinking about how to be thinking about and being part of organizations that are kind of responsible for setting these strategies. So we're a member of the Society of Human Resources. We're part of the National Association of Computerized Tax Processors. We're part of the IRS subcommittee in this area. We're a member of the American Payroll Association, and specifically we're on the committee for payroll hospitality. We're also a founding member in the New York City Hospitality Alliance. And, you know, with that, and we're a part of inside other states, we have affiliations with some other organizations that are both state related, but we really want to live and breathe, you know, how we're thinking about how we're going through this process of being your advocate and understanding where those inconsistencies are and helping you be that voice. So for us as a company, and I'd like you to figure out later on if you feel like you wanted to leverage us in that, is that we're always putting ourselves on your side of the table and helping you think through those challenges. At the same time, you know, trying to be somebody who, you know, basically has, you know, very robust, innovative, and user-friendly applications so you can figure out how you can stay focused on what you want to do, and also so that we can help you do that as pragmatically and easy as possible to stay compliant. So that's a little bit about us. I think we wanted to spend the bulk of the time today, though, having Amanda talk through, you know, the things that relate to compliance and what she's seeing in the space that she wants to kind of share with you. So, you know, let me pass this on to Amanda. Amanda, thanks for being with us today, and thanks for taking the time and putting this together to share with all those who are listening today.
Great, thank you, Jeff, and thank you, Valiant, for inviting me to join you today. I'm going to spend my time speaking about 2018 changes, compliance issues that have changed in the restaurant industry in New York for 2018. I'm a partner at the firm of Elinoff, Grossman & Scholl. I'm head of the Labor and Employment Department, and we're a full-service New York City-based business law firm, but we have a specialty in the restaurant industry, which includes labor and employment, ADA, public accommodation litigation, corporate work, intellectual property, real estate, pretty much anything that comes across your table in running a restaurant from a legal perspective, we can help you with. Next slide, please. So the first thing that you probably are all very well versed in, having seen many of these year after year after year for the last many years in New York, is that the increase, the minimum wage increases every year. And it affects the restaurant industry more than most industries because it's the restaurant industry that pays many of its people at the minimum wage, or, and we're going to talk about this in a minute, sometimes below the minimum wage with the tip credit. So if you have not yet made adjustments, you need to make adjustments immediately because effective December 31st, 2017, the minimum wage was increased to $13 if you are a New York City employee with 11 or more employees, $12 if you are a New York City employee with 10 or fewer employees, and $11 in Nassau, Suffolk, and Westchester, and $10.40 in the rest of the state. I hope that you're all by now familiar with this system where New York has changed from one minimum wage to staggered minimum wage depending on where you're located and how many employees you have. As I also hope you know, within the hospitality industry, overtime is 1.5 times the minimum wage for minimum wage workers. If you're paying them more than minimum wage, 1.5 times their regular rate. Next slide. Tip food service workers. You can pay your tipped employees who are food service workers less than the minimum wage by taking the tip credit. People often get confused by this and they say, well, we pay minimum wage. The minimum wage is $8.65, for example, if you're a New York City employee with 11 or more employees. And while it's a little bit of a semantical issue, it's an important concept to understand. And I know Valiant takes this very seriously and makes sure that its pay stubs are compliant with this concept and reflect it. What you're actually paying is the minimum wage of $13 less the tip credit of $4.35. So what that equals is the tipped minimum wage, and that's sort of a colloquial term, the tipped minimum wage of $8.65. You're really paying the minimum wage of $13 minus the tip credit of $4.35. This is very important to understand specifically because when you fill out those wage theft prevention forms, which are also frequently called the 195-1 forms, it's important that when you write the person's hourly rate, you recognize that their rate is 13 and the credit that you're taking is $4.35. If you have not done your 195-1 forms for your employees whose wages changed on December 31st, you need to do that right away. There's a $5,000 penalty per person for not having those, and it's a very hot area of litigation right now. It's very important that they be filled out accurately and correctly. As you can see from my slide here, the minimum wage changes with the tip credit for, depending on where you are, and in New York City, if you have 11 or more, or 10 or less. The other thing that I want to point out while we're looking at this slide is that there are many, many restaurants that calculate overtime incorrectly. What you have to do to calculate overtime correctly is you take the wage that the person's being paid. So, for example, the minimum wage of $13. You times that by 1.5. So you have the overtime rate of $19.50. And then you deduct the tip credit. So then you deduct the $4.35 and you wind up with a tipped overtime rate of $15.15. What we see very frequently is restaurateurs will take the $8.65 and times that by 1.5. That is incorrect. I have a question here. Can we explain the tip credit reporting pay stub compliance? Yeah, I think what I mean by that is that your pay stubs should reflect that the person is getting paid the minimum wage less the tip credit on two different line items. So it shouldn't say that the person's getting paid $8.65 an hour. It should say that the person is getting paid $13 an hour. You times it by the hours, and then they're getting, you as the employer are receiving the tip credit. So you're subtracting $4.35 for each hour that is worked. And as I said before, I know Valiant is very on top of that. Next slide, please. Now, in New York, we used to have this system, then they changed the system, then they went back, and I don't know. Sometimes I think that the Department of Labor and the legislature in New York has a goal to drive restaurateurs crazy. But they have separated out food service workers from non-food service workers. So food service workers are your bussers, runners, your waiters, etc. You are non-food service workers. These are your delivery folks. You are coat check people, and other people that you have that receive tips that are not food service workers. We see this as a large area of litigation and of improper pay among employers, that they assume that who's ever working and receiving tips should be getting the food service, quote unquote, tip minimum wage of $8.65. That is not correct. Non-food service workers are paid at a different rate. So as you can see, if you are a New York City employer with 11 or more employees, your minimum wage is 13. The minimum wage doesn't change, right? Everybody's minimum wage is the same. But they get a tip credit of $2.15, which means that delivery people should be getting paid $10.85. And again, it works the same in terms of overtime, that you take $13, times it by 1.5, and subtract the tip credit of $2.15, which results in $17.35. It is not $10.85 times 1.5. So what does this mean, the minimum tip threshold? Well, when you're dealing with food service workers, in order to take the tip credit, they must earn that amount in tips per hour. So you have to be able to show that your employees earn at least the tip credit amount, food service workers. So if you're a New York City employee with 11 or more, they have to earn on average at least $4.35 for you to take the tip credit. Otherwise, you have to make that up to them. It's a little different for non-food service workers. They have to make a little bit more for some reason. So they have to make at least $2.80 an hour in tips for you to take the tip credit of $2.15. Next slide. Fast food workers are treated differently too. Fast food is described, we'll talk about in a little bit more depth how you define a fast food worker, but basically if there's 30 outlets nationally, your fast food workers must be paid at least $13.50 in New York City. That's an overtime rate of $20.25. And outside of New York City, $11.75 with an overtime rate of $17.63. Next slide, please. In order for you to have exempt employees that do not get paid overtime, these are your managers, or potentially, depending on the size of your organization, maybe you have office staff, CFOs, directors or vice presidents of human resources. These sorts of folks that you do not pay overtime to, the people that fall into the executive, administrative, or professional categories, you need to pay them a minimum salary per week. And the threshold keeps raising in New York. So right now, if you are a New York City employee with 11 or more employees, you must be paying a salary of $9.75 to your exempt employees, to those employees that you are not paying overtime to. An important thing to note on this is that it's not just a salary test. It's a salary test, and then you have to satisfy the duties test also to make sure that they're exempt. However, if you don't satisfy the salary, if you're not making more than $9.75, if you're a New York City employee with 11 or more employees, then you don't even have to look at the duties. It doesn't matter what they're doing. So New York City, $9.75, New York City small employer, $900, Nassau, Suffolk, Westchester, $825, and the rest of the state is $870. This is going to raise incrementally over the next several years. Large employers, there's an increase scheduled for next year that will go to $1,125. And small employers, it moves to $1,012.50 next year, and then $1,125 after for 2020. And in Nassau, Suffolk, Westchester, and outside of New York City, it keeps increasing steadily through 2020. The increases are already on the books. Next slide. Okay, moving off of minimum wage, let's talk a little bit about probably the biggest change for all employers in New York State is New York State paid family leave law became effective January 1st, 2018. This law requires that employers allow employees to take job-protected leave, meaning they can't be fired for taking this sort of leave, to bond with a newly born adopted or foster child. So if you have a baby or you adopt a child or you have a child who comes stay with you for foster care, to care for a close relative with a serious health condition, or to assist loved ones when a family member goes into military service. So as you can see, this is leave to care for your family. One of the most confusing things about this law, and that has made it not play nicely with other laws, is that it's not for the individual's own serious health condition or own sick leave. It's to care for others. During the time of this leave, employees will receive pay from the state. So other than you keeping the employee employed, they're on leave and you can't fire them for being on leave. And if they participate in your medical, you have to keep them on your medical. Other than doing that, this is not supposed to cost you in that you don't have to pay. They get a benefit from the state, much like state disability payments or like unemployment insurance. It's actually, in terms of the amount of pay, it's more akin to unemployment insurance. It's actually a little higher because, as you probably know, state disability insurance is only like, I don't know, $170 something a week people get. But it runs very similar to state disability insurance in terms of the program. It is funded through a payroll tax on the employee. Really, how this works, and I hope that you're withholding from all your employees, is that you're supposed to be withholding $1.20 something, and it goes to your insurance carrier to pay the premium for this sort of a leave. Next slide. So who's eligible? Well, pretty much everybody. Full-time employees who work a regular schedule of 20 or more hours per week are eligible after they've been employed for 26 consecutive weeks. And part-time employees are employed if they work less than 20 hours, just after they work 175 days. The days don't have to be consecutive. It doesn't matter how many hours. The New York City has gone this way. And now we have this state requirement that this policy is required to be included in your employee handbook. It's a little odd because New York State doesn't require you to have a handbook. But now we're getting laws that say if you do have a handbook, you are required to include a compliant policy within that handbook. So it's time to have your handbook updated if you haven't included a policy for the paid family leave. Next slide, please. So the amount of leave and the amount of pay phases in over time. So starting January 1st of 2018, people were entitled to 8 weeks of leave. They were going to get paid from the state 50% of their average weekly wage or 50% of the state's average weekly wage. Right now, that equals $652.96. They get whatever less. And as you can see, this increases every year through 2021. So next year, people are entitled to 10 weeks of leave, 2020, 10 weeks of leave, 2021, 12 weeks of leave, and it goes up to 55%, 60%, and caps out then at 67%. In 2021. So as I mentioned before, this does not cover an employee's own serious health condition or disability. So it makes a little bit of a mess when you have to layer this statute on top of other statutes like the Family Medical Leave Act. As I'm sure many of you know, if you have more than 50 employees, you are likely covered by the Family Medical Leave Act, which requires that you allow those employees to take 12 weeks of leave for the same reasons, pretty much, as the state paid family leave law, plus for their own serious health condition. Now, this law, the New York State paid family leave law, will run concurrently with the FMLA, but not in cases of the employee's own serious health condition. So that's left labor lawyers everywhere scratching our heads saying, well, what's going to happen with new moms? Because they have their period of their own serious health condition, and then they're entitled to family bonding under the paid family leave law. So how it shakes out is that whatever they qualify for short-term disability or for FMLA, for their own serious health condition, they get to take that, plus the bonding period. So typically, right now, and this is new, so it's still all shaking out, but New York State has given women credit for 6 weeks of disability after natural childbirth, 8 weeks after C-section. So most employers are understanding that right now that means 14 to 16 weeks of protected leave for a new mom. It will increase year by year. And of course, if there's something unusual that extends the disability period for the mom, either pre-birth or post-birth, that's going to extend the period. It could be as long as the 12 weeks of FMLA plus whatever's going to be granted under the paid family leave law given the year. So if a person had 12 weeks of disability, plus right now they're currently eligible for 8 weeks of the family leave law, you could wind up with a 20-week leave related to pregnancy and then care and bonding of the child. All right, moving off of the New York paid family leave law, let's talk about a law that employers everywhere are cursing, but the reality is it makes some sense. New York City has banned salary inquiries, which means you cannot ask an applicant for employment, how much are you making right now at your current job? The reason why is because this is one of the main causes of what's often referred to as the glass ceiling. It perpetuates women being paid less than men. We all know the statistics of that women are paid a fraction of a dollar for every dollar a man makes. It's it's just borne out in the statistics of all the various jobs across the country. So when you are hiring for a position that it's not, I'm aware that your servers, your runners, your bussers, your kitchen staff, you probably just have an amount you're offering. But when you get into your chefs or your exempt positions or your managers, you are not allowed to ask how much do you make at your previous or at your current position and then pay them $5 more, because it's seen that will perpetuate the discrepancy in pay between men and women. What you can ask is, what are your salary expectations? And, I submit to you that that's probably good enough, because if their salary expectations are way out of whack with what you want to pay anyway, what's the difference how much they're making currently? Next slide. New York City Fair Workweek Law. So this came into effect at the end of November 2017. It's a very, very tough law, and it only applies to fast food employers and to retail employers. It says basically, let me back up. A fast food establishment is one that has the primary purpose of serving food or drink items, where patrons order select items and pay before eating. and it can be consumed on the premises, taken out, delivered. They offer limited service. It's usually part of a chain, and it has to be one of 30 or more establishments nationally. If you are a franchisor or a franchisee, you must own or operate 30 or more establishments, and then you fall under this. There is a required posting regarding this Fair Workweek Law if you fall under this definition of a fast food establishment. Next slide. So if you fall under the definition of a fast food establishment, you must now provide workers with a predictable work schedule. This is defined in many ways. You have to give them a good faith estimate and first work schedule in writing on or before the first day of work. 14 days advance notice of a work schedule. You have to get written worker consent for additions to a written schedule within 14 days of the start of the shift. Premium pay that ranges from $10 to $75 per change for any changes you make with less than 14 days notice. And there's this whole schedule that lays out what type of change and how much you have to pay. So if it's less than 7 days, for example, if it's less than 7 days notice, but at least 24 hours notice, and you're adding additional work time, you have to pay an additional $15 per change to that individual. If it's less than 24 hours notice, it's still $15. If you're reducing their work time or shifts and you're giving them less than 24 hours notice, it's a $75 per change. So like there is a whole schedule that's put out, but it ranges from $10 to $75 for changes that you make with less than 14 days notice. You have to pay $100 premium and get written worker consent for a clopening. Clopening it's basically when a person finishes the shift at the closing and then has to come back and open the next morning. It's when there's less than 11 hours between the shifts. And also, I found that this had really been a hardship for many of our clients, that you have to give priority to existing workers to work newly available shifts before you hire new employees. So I'm sure it's not a surprise to you that many restaurateurs are trying to keep people at below 30 hours so they don't have to be offered medical insurance. And this was put into this law sort of as a backwards way to force that issue, because before you hire new employees, if there's newly available shifts, you have to offer them to existing employees, which will often push them over to 30 hours per week. Next slide. New York City has also put a fast food deduction law into effect. And that also came into being at the end of November 2017. Basically, if your employees want you to deduct money from their paychecks to send to nonprofits that have registered with the Department of Consumer Affairs, you must do so. It does not allow contributions to labor organizations, but there is a required, I don't see restaurant employees, fast food employees running to do this. For the most part, but the important thing I think for you all to know is that there is a required posting. You can find a lot of information regarding this crazy law with its new requirements at newyorkcity.gov. There is frequently asked questions and examples, etc. Looking forward, what's on the horizon that really looks different? I'm sorry, if you can go to the next slide. The governor is talking about eliminating the tip credit. New York and 42 other states have the tip credit. As we discussed, it's a credit against minimum wage that restaurateurs can take that essentially allows you to pay your tipped employees less than the full minimum wage. So as we went over, for example, In New York, if you have more than 11 employees, you pay $8.65 an hour, which is the full minimum wage of $13 minus the $4.35 tip credit. The governor has proposed eliminating this. While on the one hand, I think it will reduce the amount of litigation that goes on, because as I'm sure you're all aware, there's tons and tons of litigation regarding the tip credit. It's going to increase your direct labor costs by an incredible amount, potentially overnight, right? So in 2019, the minimum wage is increasing to $15. The tipped minimum wage is increasing to $10, so the tip credit will be $5. But if it's eliminated, you'll be paying $15 an hour to all your employees, front of the house and back of the house, as a minimum. There are scheduled hearings where the public may speak their opinion, but you have to register. They're being held around the state, March through June. We give you the website here so you can go for information, and you can register by sending an email to this hearing at labor.newyork.gov. I think it's very important that you have your voices heard to stop this elimination of the tip credit, as it's really sure to harm, I think, the bottom line, not just of restaurant owners, but probably of your service staff as well, because it's hard to envision a way to pass this increase on to the customers without it having a backlash against the service staff. Next slide. So if you have any questions, I think Jeff and I are happy to answer them.
Yes, thanks, Amanda, for going through all that. That was great information, and I'm sure a lot of people got some great insight into that. Yeah, so I think for us, some walkaways are, there's a lot of, this presentation is available, so there's a lot of websites that you can go through to kind of help you get some good information. Restaurant.org, is probably a good site for you to go to get some good global information federally. I know that many of you are from out of state, so some of these things that are going on in New York also, are also similar things that are going on in the states that you're in. So, probably good to kind of get yourself familiar with these, and I'm sure you're already familiar with them now, but just kind of drilling down and kind of understanding them. I think one of the things that's probably clear is that whoever your CPA is or your legal counsel is, probably a good idea to really kind of get in step with them, probably even getting some insight from them on what they're using to kind of stay abreast of things, and probably piggybacking off of that. A lot of our clients do use, look to Amanda for help. So, feel free to contact her if you feel like you need her services. And then for us, we're at Valiant, we really see ourselves as somebody who's a partner with you through this journey. So not only are we putting great products together and best practices together, and compliance methods so that you can stay in front of all this, but we're also here to help kind of give you some advice and guidance, point you in the right directions for professional help, and even getting some help from existing clients that we have that can help you through some of those through some of these challenging things. So this is obviously a moving target, and it's something that we can we can all help each other out in, and give you some good advice and good solutions so that you can not be a hostage to it, but feel like you can make it work for you. And so that's kind of what we're all about. But Amanda, that was really great information, and I'm not sure. Do we have a couple of questions, Christy, with the time left?
We do actually. We do have a question from, I believe her name is Marna, and the question I can pose to Amanda is: can employees refuse to take advantage of the family leave benefits even if they are reliable?
I'm sorry, can you repeat that, Christy?
Sure. It's can employees refuse to take advantage of the family leave benefits even if they are reliable?
Well, employees do not have to take advantage of the family leave benefits, but they must make their, the employer must make the deduction and must, pay the insurance in any event, and it's up to the employee. They can't waive their right. They just don't have to take advantage of it. It's sort of like, look at it like sick time. Like, you're not going to make an employee take sick time. You're not going to make them take their paid family leave time, but you cannot discriminate or retaliate against an employee for using it.
Great, Marna. I hope that answered your question. So just, general question to Jeff. I think most people in the audience can relate to this question but how do they go about ensuring that they're currently compliant with especially New York State laws, and that they're not missing anything necessary to be compliant moving forward?
I'm not sure. I know how to validate that. I think for us, when we do things like, for example, payroll stubs and things like that, we actually get those payroll stubs kind of validated through the Department of Labor and through the state organizations that we deal with to make sure they're compliant. I do know things like I think it's the tip credit report. I think it's the 8027 report that we do, which basically tracks direct and indirect tips, and we basically follow that process. Amanda, do you have anything to add to how they go about that from what I'm saying?
Yeah, it sounds a little self-serving, but the best thing you can do to make sure that you're compliant and that you remain compliant is have vendors that you can trust and that you have an emphasis on compliance, and work with a labor and employment attorney that you trust that keeps you up to date.
Yeah, I think for us, for the things that we're covering, we go through the process of validating all those things. So I don't believe that our customers go through a process of revalidating what we're doing. So I don't, for people who are using other systems in other areas, I don't know how you'd go about that. So, so I think Amanda's.
Sorry, I didn't mean to talk over you, Jeff. But part of what happens is with many payroll companies, and pardon the French, but it's crap in, crap out. They just wait for what the restaurateurs send them, and then they pay just whatever the restaurateurs say. And then the restaurateur gets a lawsuit, and they say to me, why didn't my payroll company know this? And it's because that payroll company does not have an emphasis on compliance like Valiant does.
Yeah. Yeah, that's a good point. Yeah. So for us, for example, we spend a lot of time with the Department of Labor, the local agencies, the state and federal agencies, and really to make sure that we're doing things in a compliant kind of way. So we're way ahead of that curve. So for us, I think we feel like that we're in a given state where what we're doing is compliant.
Okay, great. So I think that's about all the time that we have for today. We're just a couple of minutes over. But I just wanted to share with the audience, first of all, I wanted to thank everybody for coming. We really appreciate it. And, we hope that you plan on attending some of the ones that we have in the future. One thing I wanted to share with you guys, if you guys wanted to connect with us, all of our information is here. You can also follow us on social media. You can also contact and connect with Amanda for any sort of compliance help you guys need moving forward. Another thing I wanted to point out that you should have a drop down on your right-hand side that says handouts. That's where you can get a copy of this presentation. And following this presentation, we're going to be sending out a recording of it. So if there's anybody that that would really benefit from this presentation, you can share it that way. Or even if you just wanted to review it or have somebody on your staff review it, we have ways to share it, and we will be following up with you guys. So of course, we're happy to answer any questions moving forward. You can definitely reach out to the email that's connected to your the email invite that you sent, received. But again, thank you so much for coming. Again, we appreciate it, and we hope that you guys all have a great day. And thank you very much, Jeff and Amanda, for doing this. This was a great presentation.
Thank you.
Thanks very much. Thanks, Christy.
No problem. Take care, everybody. Have a great day.
Okay, bye.